Okay, hello everyone. I think we're going to get started with the next panel. If you wouldn't mind taking your seats, thank you. Welcome back. My name is Noelle Leon. I'm another one of the organizers for the SPARE conference today, another class of 2014, law student here at Penn. Following our fantastic keynote from Jose Antonio Vargas, for this panel, we're going to stay in the realm of personal experience for a little while longer. In this panel entitled Strategizing Gender and Sexuality, How Personal Narratives Shape and Are Shaped by the Immigration System. So, in a sense, everything that lawyers do is telling a story. And certainly we've seen today that in immigration law, the laws are particularly driven by the stories that we, as family and as friends, as neighbors, as employers, as policymakers, and as Americans as a society, the stories that we tell about who we are and who the people are who are seeking to enter this country or claim for themselves the name of Americans. So within immigration law, asylum law is perhaps the most vivid example of the importance of an individual person's narrative in winning legal relief. Which in the case of asylum law means being able to enter or stay in the United States rather than returning to a country from which one is fleeing in fear. So it's universally acknowledged, and we've heard a lot about this today, that legal representation is the #1 most important factor for success in an immigration claim. And a vast majority of asylum applicants represent themselves pro se. So, although every applicant knows intimately his or her own story, as we heard from Tanya and Jose, telling that story to a U.S. immigration judge in a way that convinces him or her that this applicant is indeed the kind of person that we and our laws want to offer asylum to, that is a job that's trickier than the person just knowing his or her own personal narrative. And this is why lawyers are so critical in all legal work, but especially in immigration and asylum law, where the entirety of the person's claim depends on the nature of his or her story, and the context is inherently rife with cultural tension, power dynamics, and the inevitable danger of stereotype. So here today we have 3 advocates who do this critical representation, who are all fantastic, and I'm so thrilled that they could join us today. Specifically, we're going to be talking about asylum claims based on, or for LGBT applicants, and for applicants making claims based on gender-based persecution. All of these panelists have a huge amount to offer on this topic in various ways. So we'll start to my right with Professor Fernando Chang-Muy. He is a refugee law and policy professor here at Penn. And has been a huge help in planning this symposium, not just in organizing my panel, but in organizing the whole day, and has offered invaluable advice to everyone. So really thank you for that, Professor Chang-Muy. And he's a formal legal officer with 2 United Nations agencies, the UNHCR and the World Health Organization, serving as the human rights officer for its global program on AIDS. Professor Chang-Muy also is already familiar with one of our other panelists, Vicki Neilson, because they worked together on a chapter in this book, Social Work with Immigrants and Refugees, a few years ago, although this is the first time they're meeting in person after writing that book together. So next, Professor Victoria Neilson is the legal director for immigration equality, which came onto my radar about a year ago when I learned about the lawsuit that they filed against the federal government against the Defense of Marriage Act, DOMA, in the immigration context, so for same-sex couples who are seeking relief, same-sex transnational couples. So the immigration equality does a huge amount of work advocating for full equality for lesbian, gay, bisexual, transgender, and HIV-positive immigrants and their families under immigration law. She runs the pro bono asylum project there and has done a huge number of asylum cases there. She's also the primary author of the LGBT HIV Asylum Manual, a comprehensive guide for attorneys, and has published extensively on legal issues facing the LGBT and HIV positive immigrant and refugee communities, including this book with Professor Chang-Muy. She is also currently an adjunct professor at NYU Law, where she teaches the LGBT rights clinic there. And finally, we have Professor Ayodele Gansallo, who is currently senior staff attorney with the Hebrew Immigrant Aid Society of Pennsylvania, or HIAS. She also helps out in the Transnational Legal Clinic, the very popular legal clinic here, advising students on their cases with immigrants every week. She focuses her practice on complex litigation before the U.S. Immigration Court, the Board of Immigration Appeals, the Federal District Court, and the U.S. Court of Appeals for the Third Circuit, and has handled some of the very first cases involving U visas, which is a type of visa for relief for certain victims of domestic violence. She has a huge amount of experience with asylum applicants of all types of stories, and is going to share some of that experience today. So I'm going to go ahead and turn it over to Professor Chang-Muy, who would like to start this conversation just by laying out for you all what exactly is the U.S. asylum law. So Professor Chang-Muy.
It's what you said. It's right up there.
It's right up here.
So before I begin, I actually want to congratulate the Toll Public Interest Center, especially Arlene Finkelstein, who's the director, and all the students, all the 2Ls who put this together. So congratulations, but especially Alison Hollenbeck and Noel Leon. So, you can rest after today. So just to lay the groundwork for those of you who are not in my class, and for the practitioners who are just here to get your CLEs, in our laws, in a little paragraph, it's section 42 of section 101 of the U.S. Code, it says that a refugee is a person who's outside of their country of origin and who's afraid, and the fear's got to be well-founded. They can't be a crazy schizophrenic. So a refugee is a person who's outside of their country of origin, who has a well-founded fear of something called being persecuted, and it has to be based on one of these 5 grounds: their race, religion, nationality, social group, or political opinion. That's it. Because I have 4 more minutes, let me now give you the international context. So in other parts of the world, Africa, for example, some nations have signed on to that definition. They've also expanded it. And they say, we will also give refuge to people who meet this UN definition, but we will also give refuge to people who have fled external aggression, foreign domination, or events seriously disturbing the public order. So an Ethiopian could go to Kenya and say, I'm not here because of my race, religion, or well-founded fear of persecution. I'm here because of a famine. Let me stay here. And if Kenya signed on to this treaty, which is called the OAU Convention, Kenya might let that person stay. Moving on to another part of the world, that part of the world we call Central America and South America, they too have an expanded definition of a refugee. And it's cut and paste of what the African brethren have done. They say, we will give refuge to someone who meets this definition. We will also give refuge to people who have fled massive violations of human rights, external aggression, or events seriously disturbing the public order. So if a volcano erupts in Nicaragua and the person goes up to, or goes down, for example, to Ecuador, they would say, I don't have a fear of persecution because of my social group or political opinion. I'm just a farmer, but there was a volcano. Rafael Correa, president of Ecuador, let me stay. And the Ecuadorian government would say, maybe we signed this declaration, you might be able to stay. By the way, I cite that because just 2 weeks ago, the government of Ecuador said, no, we're not going to do that anymore. We're not going to abide by an expanded definition. So there's an internationally accepted definition. Over 100 countries have signed on to it. Africa has expanded the definition. The Latin American countries have expanded the definition informally. We too have an expanded definition. And here's one part of our expanded definition. And that is that if you have come from, or prove that this will happen to you, that you will undergo forced sterilization or abortion, you too might be able to claim asylum. No other country in the world has this in their definition of a refugee, and we might talk a little bit about this because this has an impact on women. But we passed this, we added this part to this provision to the statute under the Bush administration. And I'll end by saying that the very first prong of the definition of a refugee is a person who's outside of their country of origin. We've also switched it a little bit, and the last slide here is that for U.S. purposes, we do whatever we want, a refugee is also someone who can be within their country of origin. So you could be Haitian inside Haiti and ask for asylum, and if a U.S. government official interviews you, you might be able to get refugee protection inside your country of origin. If an asylum officer from the United States government can somehow go into a Cuban jail, you can apply for refuge within your country of origin. There's a number of reasons for this. It's in the name of efficiency, but that's a glitch that is actually in conflict with the first prong of the definition of a refugee, which is in the first slide, which is a refugee is a person who's outside of their country of origin, comma, has a well-founded fear of being persecuted based on the 5 grounds, and that's it. But we've expanded the definition, like Africa and Latin America, and we've added these extra 2 provisions. If you've been fleeing forced sterilization or abortion, and you can also apply for refuge within your country of origin, which is really strange because it raises issues of sovereignty, state rights, but we do that. There you have it.
Thank you, Professor Chang-Muy. I'll go ahead and put it on the first one. So there are a number of things that a lawyer has to do to technically make this claim for their clients who have experienced this persecution. So we'd just like to dive in and start talking about the first one, which is the well-founded fear and what exactly that means. So Professor Chang-Muy, again, if you could just talk about what a well-founded fear is, and then I would love to turn it over to Professor Gansallo and Professor Neilson to talk about what that means for their clients.
So this is class 3 of my refugee law class. So how do you prove fear? And can you assign a percentage to it? Do you show fear by how a reasonable person would show fear? Is it by 49%, 51%? Just how do you show that you're afraid of being sent back to Mali or China or Haiti? So the Supreme Court decision in a case called Cardozo-Fonseca got a little bit closer to defining fear. And this is how we as lawyers, we as drafting narratives, try to prove fear, that the person is genuinely afraid, that the fear is both subjective and that the fear is based on objective facts. The country they're coming from is in a hot mess, or that they will fear something, the fear is individualized. And this is the job that you as young lawyers and practitioners need to complete as to the main first prong of the definition of a refugee, that the person has to have a fear that is well-founded. So our own courts, the Supreme Court case in a Nicaraguan case, Cardozo-Fonseca, began to walk down the path of explaining how do you prove fear. The United Nations also has this little handbook. It's called the Handbook on Procedures and Criteria for Determining Refugee Status. It has 200 paragraphs or so. In paragraph 36, 37, 38 are tools and tips to triers of fact in other countries, asylum officers, immigration judges in our context, where the paragraphs say, dear reader, if you are the Italian police determining whether the person standing before you has a fear, these are things you want to think about. And it just says you've got to listen to their story, you've got to read their application, and then based on all that together, their written application, their story, the trier of facts maturity in assessing credibility, that all goes into play in determining who's afraid so that you can meet the first prong of the definition, well-founded fear.
Professor Neilson.
Sure. Yeah. Is this on? Hello? Oh, okay. Yeah, I think it is really difficult to think about, the court case that Professor Chang-Muy was talking about, saying that you have to have a 10% likelihood of persecution in your country. I mean, what does that mean? Like, what if it's a 9% chance? Does that mean you get sent back to your country? I mean, when you're talking about sort of the facts of someone's life, to try to assign a percentage like that is kind of crazy. I mean, one of the standards under the law is if you have suffered past persecution, then there's a rebuttable presumption that you'll suffer future persecution. So what that ends up meaning in a case is that it's a lot easier to win a case where you've been persecuted in the past, partly because of this legal presumption and partly because then you sort of have a story to tell. So for, in our cases at Immigration Equality, where we work with LGBT people, sort of what we're looking for when we decide whether to accept a case or not, the first question is what country do they come from? So if somebody comes from Iran, where they have the death penalty for consensual same-sex sexual acts, pretty much what we're looking for is, can this person prove that they're actually gay or lesbian? And we'll talk a little bit later about corroboration. And, I was on a panel with an immigration judge who said she looks at it this way. There's sort of a spectrum, and like the worse the country conditions, the worse, the less individualized fear you need, and the better the country conditions, the more individualized fear or past persecution you need. So, we have sort of one category of countries where things are so horrible that if you can convince an adjudicator that you actually are LGBT, your odds of winning are pretty good. On the other hand, if you come from a country like Mexico, where we do see a lot of LGBT people who've suffered really horrible things, especially transgender people. But if you look at the country conditions, or if you just do a Google search for like Mexico gay, you'll see all these improving country conditions, and you'll see like, oh, they have, you know, gay marriage now in the federal district, and the Supreme Court recently upheld it in other parts of the country, which has made it really difficult to win asylum cases from Mexico. So, you know, if somebody came to the if someone came to us and he was, you know, 22 and he just graduated from college in the United States and said, you know, I'm gay and I don't want to go back, but nothing's ever happened to me, that would probably be a hard case from Mexico, whereas from Iran, that would probably be a pretty good case as long as the person can prove he's gay. So, yeah, so maybe I'll stop there and hand it over to Ayo, but I mean, it's very case by case.
And just before one more glitch, what if you come from a country that's perceived to be gay friendly, like Brazil, where during Mardi Gras everybody goes crazy, and you know, there's gay floats? Can you have a well-founded fear of persecution I have a well-founded fear of persecution if you send me back to Brazil because of my social group, I'm gay. So those are extra glitches to the practitioner and to the students who are handling asylum claims.
And I mean, just sorry, just to answer that one question. I mean, I think especially for cases that are in immigration court, when you have somebody who comes from one of these countries where the country conditions are very mixed, it's really important to have an expert witness who can say, well, even though there might be 50,000 people at Carnival dressed up in, you know, women's clothes, that doesn't mean that the next day they're not in danger of their lives.
Right. We have the mummers here and they dress up in women's clothes and we still have persecution of gay people, right?
Before we move on to Professor Gansallo, I forgot to mention at the beginning that we would love to take questions throughout this panel. We sort of want this to be a conversation that anyone is welcome to jump into. Our panelists would love to, you know, answer, hands raised. There's going to be a microphone walking around. So just raise your hand if you have a question at any point and we will come find you. Okay, Professor Gansallo.
Thank you. I think that one of the hardest part of putting together an asylum claim is looking at this whole issue of well-founded fear, and particularly in the gender persecution realm. And when I talk about gender persecution, I'm going to talk specifically about women. I know that men get also persecuted, but I'm specifically talking about women, so please don't start sending me Twitter or anything like that. So the issue with well-founded fear is, how do you establish this? How do you present your case in a way that an adjudicator can make a determination that, yes, this person is afraid and this fear is well-founded? As Professor Chang-Muy mentioned, there are two aspects to the well-founded fear. There's the subjective and then also the objective. And you have to demonstrate that these are reasonable reasons that are reasonable to be afraid. When we look at the subjective fear, we need to demonstrate that the person in front of us, their fear is reasonable. The most common way that we establish this is through psychological evaluations. Otherwise, how else can you really show that this person is afraid? I can say I'm afraid, but does that necessarily mean that, yes, this is reasonable? So we enlist a number of psychologists, and we're quite lucky. I work with a nonprofit organization. And so we're very fortunate because we work with a network of psychologists who are willing to provide evaluations of our clients for free. With a nonprofit organization, my client base, indigent people, many of them earning less than 125% of the poverty level. So they go through a process of an evaluation which requires them to do objective tests. So there's a whole set of questions that they're asked. And those tests are, from my point of view, are excellent in determining that somebody has a fear for a particular reason, for whatever the reason is that they're saying that they're afraid. Because embedded within these questions, or this questionnaire, are questions that allow the psychologist to make a determination as to whether or not the person is genuinely afraid. And within those questions, or within the whole series of a 3 to 4 hour interview that they have, the psychologist gets the opportunity to really understand this person. They listen to their narrative, they listen to their history, they get to know what is it that you think is going to happen if you are returned. And that's really the main crux of the issue, right? What do you think is going to happen if you return to your country of origin? The second part of well-founded fear when we're looking at these cases is to say, well, is this objectively reasonable? Are the country conditions such that they can support the fear that you say that you have? So, for instance, when we do the gender persecution cases, if we're looking at, for instance, FGC, female genital circumcision, excision, mutilation, however you wish to term it, if you come from a country where FGC is not practiced, there's a problem with you establishing that the country conditions, that your fear is objectively reasonable because country conditions don't support it. But if you come from a country where 94% of the women in that country are subjected to FGC, then there's a greater likelihood that you're going to be able to establish that your fear is objectively reasonable. But what if you come from a country where FGC is, prevalent at the 94% rate, but you happen to agree with this practice? Can you truly say that you're afraid that this is going to happen to you? So there are all these different things that we have to look at when we're considering asylum applications, when we're trying to put them together. And so well-founded fear is just one of those aspects.
I just wanted to add that, so this is where the intersection of law with other industries like psychology or social work is really important. So the law school is doing great in collaborating with other departments, specifically Wharton. Wouldn't it be great if we also established stronger ties with education, social work up there, and psychology, so that law students, psychology students, social work students could work together on behalf of clients. I'm honored to serve as advisor to a group of social workers because I teach at the School of Social Policy and Practice and also here with the Iraqi Refugee Assistance Project. But these students operate in silos, and wouldn't it be great that today's leaders, today's students who are going to be tomorrow's leaders, learn to work together so that psychologists could work with lawyers, could work with social workers on behalf of our clients. But, social workers don't know anything about asylum law. Lawyers certainly don't know anything about emotional intelligence and bedside manner. And how to interview people thoughtfully and nurturingly. And wouldn't it be great if all these businesses learned from each other?
You're excluding me in that, though, aren't you?
I'm excluding you, of course.
I think we have a question up here, actually.
Thank you. My name is Gustavo Silva. I'm a student here at Penn Law. And the one asylum case that I worked on was an FGM case with a client from Sierra Leone.
What is FGM for the rest of the...
Female genital mutilation. She had been subjected to that practice in Sierra Leone and then came here with her 2 daughters. And we were worried that we wouldn't be able to prove a well-founded fear because she had already been mutilated. And I was shocked to hear that there was some case law somewhere saying that, if you've been mutilated already, you can't be mutilated again or circumcised again. So therefore, you won't be able to prove that fear. And we were worried about that. I don't know if you can expand on that and how that affects your clients who are trying to run away from FGM.
Matter of Chang, but go ahead.
Well, actually, no. I mean, so, there's this whole, I guess you're thinking of matter of AT. And so this case went through a number of different mutations, if you like. So the initial decision of the Board of Immigration Appeals was that FGC, FGM, however, is a single act and that it can't be performed again, which is actually not true, okay? The way that the custom operates, I mean, if a woman has a baby, for instance, then she's unstitched, and once she's had the child, she's stitched again. So it's not a single act. This particular case, the Attorney General took to himself to review and made a decision and said, well, actually, you're looking at this in the wrong way. Because what you're looking at is the question of whether this same act of persecution can occur again. But that's not what the statute says. The statute says, if you have suffered past persecution, okay, you've established that there's a likelihood of persecution, which doesn't have to be the same act that already occurred to you. You can look at other things in order to determine whether or not there's a likelihood that you're going to suffer persecution in the future. And so you can look at issues like, discrimination against women. In many countries, women are, they're not allowed to own land. The opportunity to work is very limited. The opportunity for education is limited. There's domestic violence. So there are many different ways that persecution can happen in the future. It doesn't have to relate to whether or not there's going to be FGC again. So there is the possibility of establishing that this person qualifies for asylum.
And I mean, I think that point, I mean, I think your story and that, case that started out so badly at the BIA really just points out how vital it is for asylum seekers to have attorneys because, people, I think Jose Antonio Vargas before said, lawyers try to see things in black and white, but people's facts are messy and they're gray. And what we're doing as asylum lawyers is taking those gray facts and, highlighting the white and hiding the black or vice versa. But, not being untruthful ever, but highlighting what's helpful to the case. And so for many cases, just taking, helping someone to answer the question in a way that's most helpful for them will be the difference between winning or losing. So if you say to someone like, well, this already happened to you, so it's not going to happen again, if the person just says, oh yeah, I guess you're right, that could end up being a loss. Whereas if the person answers that and says, well, yes, it did happen to me, and I'm afraid that this is going to happen in the future, then they win. And that's really what your role as a lawyer is, to help them frame their gray facts in a way that complies with the law.
For those students here who are in my 14-week refugee law course, what Vicky said. So in week 7 of a 14-week course, my students fan out and they interview real-life people. We took a client from New York and they interviewed her. Actually, she lives in New Jersey, so my students interviewed her here. We interviewed clients from the Pennsylvania Immigrant Resource Center, Hebrew Immigrant Aid Society, Nationality Services Center. And after those interviews are done in week 7 of my 14-week course, the students come back and are all complaining that it's messy facts. Like, what's this? What do I do with that? And that is part of this exercise, to try to get you to put the messy facts into some sort of order, a la the prongs of the definition, to try to find country of origin information that will support whether the objective part of the test, is there something going on in the country, like what the immigration judge says, bad things happening to gay people, etc. And that's the job of the law student and the practitioner tomorrow, should you want to do this kind of law, to put all this into shape, into a package that will then be delivered to the adjudicator, an asylum officer, or immigration judge. And again, broken record. This is why lawyers, psychologists, social workers are so crucial and so important in this part of the immigration law, the asylum part of the immigration law.
Thank you. We're going to move on to one more question before we move on to the next set of questions.
Hello, my name is Moses Ashaba. I'm an international student at Temple Graduate School, and I happen to have taken immigration and refugee and citizenship law and international human rights protection. So I have these questions. During the course, my immigration law course, I realized that there's a case about this Iranian lady who petitioned, actually in Philadelphia, for asylum because she had converted to Christianity, and she claimed to have, she would be prosecuted on returning back home because of her conversion to Christianity, and she wouldn't wear the veil again. And correct me if I'm wrong, I think she was denied the asylum based that she wouldn't be singled out because of her religious affiliations when she went back home. But I realized that the standard of well-founded fear is absolutely hard to meet. So it's hard because she has to prove beyond reasonable doubt to the judge, the immigration judge, that she has that fear. And it's hard to prove fear. And the other case is this Chinese woman who claimed that she would be forced to abort because she had already a child in the US, and then if she went home, she would be forced to abort the kid she had, the second kid she had, because of the one-child policy. My main question is, I come from Uganda, where the LGBT rights are still in the doubt. Parliament is soon passing a bill to banish LGBT and organizations that support LGBT. So how are you, as human rights lawyers and people concerned, would you take the country's history, or it's an individual basis on evaluating someone's well-founded fear for persecution? Thank you.
So just to kind of streamline that, and so we can just move on to the next set of questions, I feel like that sort of the general question would be, when you look at the individual claim in the context of the country conditions, what are you looking at? Are you looking at the history, or just sort of legal markers or social markers of what's going on in the country when you make a determination of fear?
It's all of the above. It's the objective is what really is happening in Uganda, what anti-gay laws has the parliament passed. So as the immigration judge says, the worse the situation of that particular group, the easier it might be for the applicant. But then you also have to balance that, the objective, what's going on in the country, with the person's subjective narrative. And this is where lawyers and law students help put the case together to make a claim that I really am afraid to be sent back to Uganda. So it's all of the above.
And one of the sort of ironies, at least with LGBT claims, is that sometimes the more dangerous it is in the country of origin, the harder it is to prove that the person is LGBT, because if the person is so afraid that if he acts on his sexual attractions in his home country that he could be killed or imprisoned or beaten, he might not act on those impulses, which then makes it that much more difficult to prove that he actually is gay. So it's this sort of catch-22 that we get sometimes.
Great. So somebody's already mentioned this a little bit, but in making these kinds of claims, you have to have a certain level of credibility, and you have to have a certain amount of corroboration in order to really make these claims stick. So in terms of corroboration, what challenges, Vicky, have you seen in your work in these types of claims are sometimes very, very hard to have evidence of because it's sort of an inherently underground, often thing?
Yeah, I mean, I think in the best case scenario, if a person has a partner, especially in the United States, or if they come from a country where a partner feels comfortable putting in some sort of letter or affidavit talking about their relationship, which corroborates the applicant's own story, that can be really helpful. I think, sort of as Aya was talking about before, in terms of, I think working with mental health professionals can be very helpful, not just for establishing the fear, but for LGBT cases, if the person has been to counseling to talk about sort of coming out issues, that can be very helpful. Sometimes we get sort of negative evidence where, someone will have a letter from their father saying, now that I know that you're, abnormal, I don't ever want you to come back to, don't ever come back home. And that can also be helpful. Sometimes we get more creative and look at sort of social media. So we'll have like someone's Adam for Adam page and print out a copy of that. I mean, it's interesting. And I think in the United States, the adjudicators have actually been really good with LGBT cases, at least at the asylum office level. And we've actually, in the last couple of years, they've put released, USCIS has released an LGBT training module for asylum officers, which Immigration Equality collaborated with them on, and I've been actually training all of the newly hired asylum and refugee officers on sort of what are appropriate questions to ask, what are not appropriate questions to ask. So, I read sort of horror stories about some of the adjudications of asylum cases in Europe, which is sort of light years ahead of us on couples recognition for LGBT cases, but seem to be really behind us on asylum cases where, it seems like they have asked people for sort of graphic sexual tapes or have sort of said, well, if you can be discreet and go back to your country and not be, persecuted, then that's what you should do. So in the United States, I mean, certainly when I do trainings with asylum officers, I say, please, don't ask for anything graphically sexual. If you're offered it, politely decline. I mean, I think it's appropriate, for someone to say, here's a picture of my boyfriend and I visiting the Statue of Liberty, but, not anything that goes beyond that.
By the way, Adam for Adam is old school. What the younger generation is using is Grindr, so I'm told. I don't know.
That you know that.
I don't know about that. But
Professor Gansallo, I don't know if you have insight into difficulties with corroborating persecution when it takes place, I imagine, so often in a very private space.
Yeah, I mean, absolutely. I mean, if you think about domestic violence, for instance, and if you think, I mean, just within the context of this country, you might see a work colleague who comes in with bruises and she may say, well, I fell down the stairs, right? So you don't know anything different because you weren't in the household when whatever happened. And it's the same with asylum applicants because much of what happens is within the household. But it's actually worse because many of the clients that we deal with come from cultures where domestic violence is the norm. So the expectation is that if you're a woman and you have been given in marriage, you now belong to this other family. And your husband can treat you as he chooses. And for you to seek legal recourse within your country, it's often very difficult because the police don't want to get involved, other family members don't want to get involved. This is a family issue. So therefore, you may have the physical scars, and if you do, then it's possible for us to do a forensic examination and have a doctor say, yes, these scars here are consistent with the story that the client is telling me as to how they acquired these scars. But, there's nobody around, well, sometimes there are people around, but it's, I don't remember the name of the case, but in one of the cases, the judges said, you can't expect to get a letter from your persecutor saying, I did X, Y, and Z. So once again, we have to look to external evidence that we can use for corroboration. The most important part is actually how the applicant tells their story and whether or not they come across as being credible. Credibility is an essential part of asylum cases. But also, in order to bolster the application, we'll get psychological evaluations, which once again can help to demonstrate that this person is telling the truth as to how they acquired certain injuries.
Noelle, I'd like to also flip your question around. So you've asked us, how does someone corroborate their story? So it's true that the applicant has the burden vis-a-vis the lawyer or the student or the psychologist to tell the story. But wouldn't it be great if the adjudicator, be they the asylum officer or the immigration judge, was also trained in a holistic way about different cultural norms? So for example, someone, not to degenerate into stereotypes, someone from Asia might be telling their story and be looking down at the floor, and the adjudicator might say, this person is lying. I don't believe anything they're saying because they're shifty-eyed and they're not looking at me in the face. But wouldn't it be great if the adjudicators were given training, and I know that they get some training, on different cultural norms and different ways that different cultures talk and narrate, so that the burden is not just on the teller, the speaker, but also on the adjudicator, so that both partners together, the speaker and the adjudicator, I guess I'll use the word, give the person the benefit of the doubt.
Yeah, thank you, Professor Chang-Muy. That also brings me to another question I've been wondering about, is whether you guys in your practice have seen differences in how easy or difficult it is to make asylum claims for people from certain countries or cultures as opposed to others, because perhaps their narrative style more closely matches what Americans or Western law expects persecution to look like, or corroboration or domestic violence or any of these issues.
Well, no, go ahead.
I definitely think that cultural differences can be really challenging in the LGBT arena. I mean, I think that there's been so much progress in the United States and sort of the Western world, and how we speak about LGBT issues, that sometimes it's hard when you're talking to someone from a culture where those issues are so taboo that they don't sort of use the same. I mean, when I say they don't use the same language, I don't mean that we literally, although that's often true as well. But I mean, they don't. Like one example, I was meeting with an Egyptian client at one point, and I was asking him. He and his boyfriend were both in the United States and were both in removal proceedings in front of different judges. And I was asking him, how how the two of them had come to be boyfriends. Like they worked in the same store and eventually became romantically involved. And I said, how did that come about? And he said, well, we were talking to each other, and the way he looked at me, I thought he had the same problem that I have. So I mean, it's just like such a different, like that was his way of describing his sexual orientation, that they had the same problem. Likewise, I was working with an Indonesian client who, said, I hate the word gay, like, please don't use the word gay around me. So I had to, he preferred the word homosexual, which is a word that I find really kind of pejorative. But, it's sort of, you just have to kind of meet the client where they are, and then you have to, as their advocate, sort of be their translator to the adjudicator, so that if what the client is presenting is not, sort of, I'm out gay and proud, the way that the adjudicator might be expecting the applicant to present themselves, you have to sort of explain, why, coming from where they're coming from, that's not the way they're going to present themselves.
Professor Gansallo, do you have any thoughts on that?
I think that the difficulty with the gender cases is, as you said, it's with the understanding of what is the cultural norm in this particular country that your client comes from. And you can provide that information through the objective evidence that's going to be part of your evidence package. But I think that it's also about how the client actually presents. So I remember many, many years ago, I dealt with a domestic violence case for a woman from Liberia. She was Baha'i, and she was an older woman. And the whole way that she presented herself was very, very flat. And there, obviously there could have been psychological reasons for that as well, but this was just the way that she presented, and she was very humble. And I remember this was in the days when we had a particular immigration judge who thankfully has been taken off of the bench. But he decided that because when she spoke about parts of her story, which included her husband coming at her with a knife, because he was going to stab her, and she showed no emotion, he determined that this could not be a credible story. And the way that his general personality was one where he badgered her, and he was vicious with her. And I remember, I don't like to tell the story because it gets me very emotional, but I remember this is one of the first cases in which, when I was in immigration court, I was crying because I felt like I was also being violated. Here I am representing this woman who had gone through so many things in order to be able to sit in front of the judge and explain her story, and yet really what was happening to her, and I sort of felt I felt some responsibility for it. What was happening was that she was being re-violated. And just because this judge who had a propensity to, disbelieve everything that everybody said, was just disbelieving her because she just sat. She was very regal. She didn't show any emotion. She just told the story. But that is what was culturally normal for her. And I'm pleased to say we have 4 different judges, and they have different approaches. I'm glad that we don't have this particular judge. But those are the things that our clients have to overcome in order to be successful in an application, sometimes.
But this is why I say that wouldn't it be great if we as lawyers got training from psychologists and that the immigration judges got training from psychologists and were exposed to words like lack of affect. And so when sometimes people have no affect, it's because they've been so traumatized that they're just blank. So that does not mean that they're not credible or lying. It's just that maybe they're trying to disengage from the traumatic act. But in law school, we never hear about these words, trauma, lack of affect, no blinking. We just learn about torts and contracts. And so wouldn't it be great for the immigration judges also to be exposed to this other world so that they can become better adjudicators? And winning or losing is just like, Noelle, you got into, you're a total public interest fellow based on many facts, your essay, your grades, where part of the country you're from maybe, et cetera. So does winning and losing an asylum claim is based on how the person presents, the adjudicator's training or lack of training, the goodness or badness of the application form that we as lawyers put together, the country of origin information that we attached. So it's a bunch of factors that go into winning and losing, winning or losing, and it's not just one. But hopefully conferences like this raise people's awareness of putting all this together and dotting all the I's and crossing all the T's so that people can win.
Thank you. We have a question here, actually.
Good afternoon. Thank you very much. This is an interesting panel. I'm Mary Meg McCarthy from National Immigrant Justice Center, and we work a lot with Vicki at Immigration Equality. I think I have 2 areas I just wanted to explore with the panel a little bit. One is drawing off or building off of this cultural issue is I think it's really challenging to represent individuals and gather the data and help them communicate and translate their story when they're detained. And I'm wondering how you and the panel have provided legal representation to detained asylum seekers or refugees. And as we know, that's really an underserved population in terms of access to legal services. So I think it's really important. And then my second question, I'll just throw them both out and you guys can handle them however you want, is about the 1-year asylum deadline. We have a number of cases in which our clients, many of them LGBT or gender-based persecution cases, they just weren't aware of the fact that they were eligible to apply for protection under U.S. asylum laws. Or they were in a situation where they were not free to apply, specifically the gender-based cases. And I mean, hopefully that's one thing we can see possibly changing with immigration reform. But in the meantime, it's something that we're dealing with, and I'd be curious to hear the panel's reflections on that.
Thank you. So we actually we're planning already to come back to your second question, so we'll get to that in a little bit, but if you guys want to talk about the first one.
Yeah, I mean, that's such a important, I mean, both of those are such important points for asylum. I mean, detained people, everyone benefits from having a lawyer. If you're in detention, I don't know how you could ever win a case without having a lawyer. I mean, we were just putting in written comments to the FCC telling them that they should collect phone calls from detention facilities, and I asked our office manager to find out how much money we spent last year accepting collect calls from detention facilities, and it was $2,500. Like,